As a member of the Board of Assessment Review, it's important that you understand the rules and procedures associated with a grievance day hearing. Let's take a look at how a typical hearing is properly conducted. While not all hearings are held in the same manner, by law, they must comply with the following rules. First, a grievance hearing cannot be held without a quorum. In this town, the board is composed of 3 members. If a board has 5 members, 3 represent a quorum, and if 3 members, 2 is a quorum. Since all of the board members are present, the hearing can commence. Second, grievance hearings must be open to the public. Make sure you have seating available for those waiting or observing. Third, minutes of the proceedings must be taken throughout the hearing. In this case, the board has chosen to use a tape recorder in lieu of a note-keeper or stenographer. Last, you may only accept grievance forms completed and filed on or before grievance day. There are no exceptions. The law does not prescribe formal rules for the hearing's proceedings, but there are best practices which should be followed. For instance, the chairperson should commence the hearing by introducing the members of the board as well as the assessor. The chairperson should also briefly explain the purpose of the hearing and what is to be expected. Finally, the chairperson should note that the meeting's minutes are available to the public upon request. Next, the chairperson should swear in the assessor. In this scenario, the board has scheduled time slots for each complainant who filed their form before grievance day. This helps avoid long waiting periods and possible confusion. However, time should still be reserved for those who submit their form on grievance day, as they are equally entitled to a hearing. As with the assessor, any complainants or witnesses called forth should be sworn in. Before the case is heard, check to see whether the complainant has a completed grievance form. If the grievance form is missing or incomplete, you should instruct the complainant to step aside and fill out the form. Either you or the assessor should have copies of the grievance form and instructions available to hand out. While you may answer some general questions about the form, neither you nor the assessor should assist the complainant with filling it out. Your attention should be directed to the next scheduled complainant. Once the grievance form is complete, you can recall the complainant at the next available time slot. The complainant does not need to be sworn in again, but should be reminded that they're still under oath. If the complainant was not present at the start of the hearing, you may want to introduce yourselves and the assessor. You might also review the purpose of the hearing and what's to be expected. It's important that the complainant not feel intimidated by the hearing process. Allow the complainant to summarize why they believe their assessment is unfair. Remember, the purpose of the hearing is to give the complainant the opportunity to contest their assessment. The board should not entertain debates on taxes or politics. Once the board understands the basis of the complainant should be asked to present supporting documentation if they have not already done so. As a member of the board, your primary role is to gather the facts so you can make an informed decision, so use this opportunity to ask questions to the assessor and complainant. If necessary, request additional documentation from the complainant. Don't feel compelled to arrive at a decision on the spot. At the end, you should feel confident you understand the facts and issues at hand. Above all else, be objective. Don't take sides with either party, and do not hint at which way you're leaning. The chairperson is responsible for ensuring the hearing runs smoothly and peacefully. The chairperson should always maintain control of the hearing, never allowing the assessor or complainant to dictate the discussion. Although the assessor must never be allowed to cross-examine the complainant, the assessor is entitled to offer comments for the record on any complaint. Furthermore, the chairperson must ensure that everyone treats each other with respect and courtesy. Participants should never interrupt, talk over, or debate each other. Likewise, comments from others waiting for their hearing should not be tolerated. The purpose of this hearing is to gather the facts, not to deliberate. When the hearing reaches the end of its scheduled time, the board must adjourn. If it is at the end of the day and there are still complainants who have not been heard, the chairperson should schedule another hearing at a date predetermined by the board. In this scenario, the town recently conducted a reassessment to update the assessment rule. The town's stated level of assessment is 100%, so each property's assessed value should reflect its full market value. Depending on how long it's been since the last reassessment, Many property owners may be surprised to see their assessments dramatically increase. This complainant is contesting his home's updated assessment. Since this is an assessment of residential property, the assessor used the market approach to estimate the home's full value. The taxpayer believes the assessor overvalued the property and requests the assessed value be reduced to his own estimate. By law, the assessor's estimate is presumed correct unless proven otherwise. For the board to consider reducing the assessment, they must be presented with convincing evidence from the complainant.
I see that you've attached to your grievance form a list of recent property sales, including the description of the properties and the sale prices. It looks like you have 3 in all.
That's correct. Those houses are very similar to mine, and the sale prices you see are much lower than what the assessor came up with.
Ms. Novak, did you have enough time to look into these sales?
Yes, I did. The first property Mr. Jones listed was actually sold as a result of a foreclosure, so it was not arm's length. In other words, it was not sold at market value. The other 2 properties were sold at market and are comparable to the property in question. I do have my own list of sales, however, that are more indicative of the assessment, some even higher.
You also submitted a copy of a valuation statement from your bank.
I highlighted the part where it shows what my home is worth, and again, it's much closer to my own estimate than the assessor's.
According to this document, the valuation was done over 5 years ago. Has the market changed since then?
Well, according to my analysis, this neighborhood has seen a steady rise in home values over the past few years, so the bank statement may have been fairly accurate at the time, but not now.
The next complainant also had his home's assessed value increase due to the reassessment. However, his argument is much different than the one before.
For the past 10 years, my assessment has stayed the same, and I always paid what I owed and paid it on time. Now I get this notice stating it's going up and I have to pay more. I could barely afford to pay what it was before. You guys leave me no choice but to sell my house and move out of this county.
I understand your concern, Mr. Cunningham. On your grievance form, you gave an estimate of what you believe your assessment should be. Can you provide us with any evidence to support that estimate?
Well, that was my assessment from last year, which I think is fair considering my income, which hasn't changed. If you wish, I can show you a copy of my federal return that I just filed.
I don't think that would be help in determining how much your home is worth. Do you have anything from a bank or a real estate agency?
Look, I don't know what you guys want from me. I'm just here to say you can't get blood from a stone. That's all I have to say.
Ms. Novak, is there anything you would like to say?
Well, I believe the assessment for this property is fair given the condition and the current market. And I'd also like to mention that Mr. Cunningham is receiving the Enhanced Star exemption, which gives him a break on his school taxes.
Thank you, Mr. Cunningham, for coming in. We'll make a decision and notify you of the result by mail.
Great, thanks.
In this case, the complainant is disputing an assessment on an apartment building which he owns and rents out to tenants. He does not understand how the assessor came up with his estimate and insists it should be much lower. Since this is a commercial property, the assessor used the income approach to estimate the building's full market value.
So, Mr. Collins, I understand you're disputing your assessment.
Hey, I wish my property was worth what you say it is, but the sad truth is I'm struggling. I haven't been able to raise the rent in 4 years. I got tenants moving out, leaving the place a complete mess, which I have to deal with, while even the utility company's giving me the runaround.
Mr. Collins, can you tell us how you arrived at your requested value?
Well, it's what I think it's worth. And like I said before, I keep having expenses that keep going up and up and up.
Ms. Novak, can you tell us something more about this property?
Sure. This is a 6-unit building on Maple Street that appears to be in good condition. And back in January, I sent Mr. Collins an income and expense form to fill out, and I never received it back in my office. I used this information to come up with my value estimate. So without it, I instead used an industry index to estimate the income and expenses and ultimately the value.
I looked at that questionnaire, but I don't have time to give you every little detail about my business. This is not my only job, you know.
Do you have a ledger or a journal you can show us?
I'm really not an accountant, and my records aren't really organized. Look, if I filled out that questionnaire, would that be enough?
Okay, Mr. Collins. If you can give us a completed questionnaire by this Friday, we'll accept it as evidence before we deliberate. I also suggest that you give a copy to Ms. Novak as well. Are you okay with this arrangement?
That sounds reasonable to me.
During the deliberation, only the board members who participated in the grievance hearing should be present. Neither the complainants nor the assessor may be present. The only exception is the municipal attorney, who may be called in to address any legal questions the board has. Here, the board will deliberate on each of the cases we previously heard. They begin with the complainant who disputed the assessment on his residential property.
Okay, let's begin with the case of Mr. Jones.
Now, I think Mr. Jones actually did a pretty good job. He had a wide number of comps, but I do think he was a little too selective. The assessor gave us a wider array of more appropriate sales.
Yeah, I definitely agree. But looking at those sale prices, all of them were not as high as his assessment. So while I don't exactly agree with his numbers, I can understand where he's coming from. I think what threw him off, though, was that statement that he presented from the bank.
That's a good point. He may have thought that was good evidence, but it's simply so outdated that it does not support his value. I think we should take another look at the comparable sales.
After further deliberation, the chairperson recommends lowering the assessment, but not to the amount the complainant requested. The majority of the members agree. Next, the board discusses the complainant who felt he could not afford an increase in his taxes.
Okay, let's begin the case of Mr. Cunningham.
This one's pretty cut and dry. He had no case. He provided no evidence, at least nothing relevant. The assessment should remain unchanged.
But I can't blame him for being upset that his assessment went up so high. It's still the same house, and he's paying even more. It should qualify for some relief.
I'm not saying I don't feel sorry for the guy, but we can't lower an assessment based on hardship. If he pays less, someone else pays more.
You're right. We have to be objective with each case. From what we have from the assessor, it appears that she gave him a fair value on his property. Whether or not he can afford to pay the taxes is irrelevant. I believe that this assessment should stay the same.
Finally, the board discusses the complainant who contested the assessment on his apartment building.
When we last spoke to Mr. Collins, he promised to give us the questionnaire that he had failed to originally provide to the assessor. In reviewing his documentation, though, I don't find any evidence that would support a reduction in his assessment. Perhaps we should review all of the evidence again.
The board now proceeds to record their vote in public.